I will now call for argument case number 118941, State of Kansas versus Christopher Sean Petilla.
Michelle Davis, appearing on behalf of Christopher Petilla. May I please reserve 2 minutes for rebuttal?
2 minutes is reserved.
This is a case where this van full of 14s or young men pulls up at the house, and Mr. Petilla is driving. You've got Fulton in the front seat, Jonah Munch is all the way in the back, and Martinez is in the middle. And there's some conflicting testimony, but basically Fulton says the van's coming, slowing down. He's about to get out when he hears the shots ringing out, and it's Martinez who's doing the shooting here. And Mr. Petilla said that he heard the shots and he sat for a second, and then he's trying to get the van in gear out of neutral, but the van keeps rolling. Munch said the van stopped briefly at trial. At the preliminary, he said 10 seconds, but at some point the van keeps rolling. But the initial shots are fired at Brian Miller, who's sitting in a chair. And it's kind of a duplexy looking house, so that it's more long than it is wide. So he runs to the side of the house, and the van keeps going, the shots keep firing, and eventually he's shot and killed on the side of the house, or he ends up at the back. So the state prosecutes Mr. Petilla under theory of aiding and abetting premeditated murder, charges felony murder in the alternative, and then a whole bunch of felonies. The jury, Mr. Petilla's defense here was that they were going to fist fight, that the plan here had been, to confront them, and then if there were problems to fight. Apparently the jury believed that defense because the jury convicted him of involuntary manslaughter, which is a killing in the commission of a misdemeanor attempted battery. The jury, the very first count, if you look at the verdict form, the jury had the option to convict of premeditated murder and intentional second. Those were on one verdict form. And the jury declined to convict on both of those. So the state agreed with the defense here, and then the jury went to felony murder, and they convicted Mr. Petilla of a killing done while these other crimes were being committed, because basically the state alleged that when he fired the gun, two of the initial shots went into the house, and so they charged there was a child in the house, aggravated endangering, and then criminal discharge of firearm, and an aggravated assault, and those were the underlying felonies that the state claimed the killing resulted from. So on appeal, we challenged the sufficiency of the evidence to support the felony convictions, basically all of them.
And the jury found your client guilty of all three of the underlying offenses separately, in separate counts from the felony murder as well. So.
Yes. On an aiding and abetting theory, yes. Which is difficult, because then aiding and abetting, you're specifically intending to assist Martinez, basically was the legal theory, in one of the act, in doing a reckless act, or so basically, there are a lot of jury instructions. So we've got the sufficiency of the evidence, then we claim that jury instructions are inaccurate on felony murder, and basically the failure to instruct on lesser offenses, which were misdemeanors, and then multiple punishments that Mr. Petilla received. Those are the issues in our briefs. There's a lot of issues here. I think that the important thing is basically the felony murder conviction. I think we're very clear in our brief that this killing didn't result from endangering a child. Ms. Martinez intentionally shot Brian Miller. It was the felonies actually resulted from the intentional killing, and that it was error. That basically the jury couldn't convict him of aiding and abetting a shooting at the dwelling when the culpability apparently was driving away from the residence, and making it, the state's whole theory here was basically supplied by Munch, which was that with the van rolling forward, somehow that made it easier for Martinez who was trying to kill Brian Miller from the very beginning, made it easier for him to kill, and that's what the state argued, that Mr. Petilla was liable because by driving the van, he made it easier for this shooting to take place. And then basically that the jury could come to this verdict even though it wasn't supported by the facts because of the inaccurate jury instruction, that all they had to do was find that the killing was done while these felonies were taking place, instead of that the killings were a direct result of the commissions of the felonies. And so that's why the jury could return a verdict even though the facts didn't support it.
Do you agree that this sufficiency that only one of the underlying felonies needs to stand and not be reversible in order for us to affirm the felony murder conviction?
Yes. Yes.
So no dispute about that.
No. And then, unless again, also, I think that the failure to instruct on the misdemeanors also because you need the felony in order to get the felony murder. So you're right that they did convict of felony, but it's our contention that there were misdemeanor offenses that could have been instructed. And if that's error, then it also reverses the felony murder conviction. I think just, and specifically too, they enhanced the sentence here with the great bodily harm, that the criminal discharge of firearm resulted in great bodily harm. And I think one thing I did want to point out, so he gets the 25 years for the felony murder, and then he gets an additional 200 and some months because of the great bodily harm consecutive resulting from the criminal discharge of the firearm. But I think there's a difference between an act that results in great bodily harm and an act that results in death. And in this case, you had an act that results in death here, not great bodily harm. And I understand that in shooting somebody, you're causing great bodily harm, but that really wasn't the result. The result here was death. And so when we're saying multiple punishments, it's not really that the offenses, it wasn't the same offense. The offense here was a criminal discharge of firearm. It's the result that they're enhancing for. And that harm was inappropriate because with the felony murder conviction, he's already being punished for the death. And it's inappropriate to then also punish saying that there was a result of great bodily harm. And that's not what the legislature would have intended.
I can't point to a specific case, but it seems like we've had others where that's been the underlying felony and we've affirmed that death being great bodily harm. Do you have any authority that goes the other way?
Yeah, I don't. Yeah, I in your case law, I've seen where there was criminal discharge of firearm you're saying is not multiplicitous with felony murder. But I didn't see any case specifically with the issue that I'm raising, which is that they then used the result to punish him twice for the result.
But doesn't that get into a factual inquiry, which we don't do in looking at the multiplicity? We look instead at the elements.
But I don't think that's what I'm trying to say. I don't think I'm not. My argument isn't that these are the same offense. Clearly, you've said these are different offenses, and so I'm saying we don't apply the same elements test. This is strictly an issue of whether the legislature would have intended for somebody to be punished for death and for great bodily harm. The offense is the discharge of a firearm in a dwelling. That's all the state needs for felony murder. There
was a non-fatal shot to the buttock, wasn't there, or below the buttocks or something?
There was a flesh wound.
Does that matter? Does that change your argument?
No, because there was no testimony that caused great bodily harm. I mean, that wasn't. This was all.
Isn't that a natural inference that you can take from a gunshot wound to? You would say that's not great bodily harm just to have the gunshot wound.
But I mean that wasn't the state's theory that support the criminal discharge of firearm resulting in great bodily harm. That wasn't their theory. They didn't specify that as a separate. They didn't specify that was a separate harm. The harm here was the death. That was it. They didn't try and say he suffered great bodily harm from a flesh wound. I mean, that was never a theory at trial. So basically what you're doing here is you're saying we're giving him a life sentence for the death. They were adding on 200 and some months because the only option the jury had was to find great bodily harm. They didn't get the lesser. They didn't get the option of the lesser criminal discharge just of a firearm. The only option they had was to find resulting in great bodily harm. And again, it's our contention that the discharge of a firearm didn't result in great bodily harm. It was intentionally shooting somebody that resulted in death. And there has to be a difference there between the great bodily harm and the death. And also, just because the statute contemplates harm to an occupant, not to somebody outside. So that concludes my presentation.
Is the basic driver of your sufficiency argument on the endangerment of the child just that they didn't know the child was there?
The state didn't present evidence that they were.
And that's absolutely necessary. The the jury can't draw an inference that because it's a dwelling, it's getting shot up, that there
So-
may be a child involved.
So then I cite Herndon, and I mean, Herndon, I think, had excellent analysis of this issue. Because otherwise, every time a dwelling is shot at, you could say you may be endangering a child, right? If there happens to be a child inside the house. And so basically what it says is that it specifically has to cover, there has to be a knowledge of a child, because that's what the crime's punishing, is and not just any person. And then also the conscious disregard of a substantial risk to a child. So you would have to be aware of the presence of the child to disregard a substantial risk. And then also, supposedly this is the first 2 shots that were fired. If the jury believed the defense here, that was the premeditation. I mean, if the jury believed that he was assisting in this, then they would have convicted him of premeditated murder. I mean, it makes no sense. The culpability here was for the shots that were fired, not the 2 shots that went into the house. They didn't find Mr. Patillo culpable for that. If they had, they would have come back on premeditated murder. So those were the 2 shots that went into the house were the ones that they convicted supposedly for endangering a child, and that was not the conduct they found Mr. Patillo responsible for. And then they didn't prove the child was endangered. For felony endangerment, you have to have physical harm. There's case law on that I cite in my brief, that this child was not harmed. You have to have actual physical harm to the child. They didn't instruct on the lesser misdemeanor of regular endangerment, which would have been the reasonable probability. The may be endangered, the misdemeanor fit the facts of this case. They never instructed the jury on that. So, over answered your question.
Why would we not apply the invited error doctrine to your arguments about, on both causation arguments, both as to the felony murder and as to the criminal discharge, since those were identical to defense offered instructions?
Those are standard pattern instructions. There wasn't any invited error here. Counsel just requested the standard jury instructions. He didn't invite any error by the court, and this court has held that just requesting standard jury instructions isn't enough. And I think I cited in my reply brief, but basically it has to be a situation where counsel invites the court to do something that the court otherwise wouldn't do. I mean, I'm simplifying that analysis, but basically it's along that line, that just asking for the standard pattern instructions isn't inviting error. Invited error would be saying you should give those instructions, but it's strategy, and I don't want you to. For example, the classic would be we don't want you to give lessers, we want to go all or nothing. That's invited error. If you're just asking, the defense counsel didn't invite this error by asking to give standard jury instructions, because that's what the court's going to do anyway. You would invite error if you ask the court to do something it's not going to normally do, or that goes against what is standard practice. So that would conclude my comments. Okay, thank you.
Okay, thank you. Mr. Obermeyer?
Good morning, Madam Chief Justice, and may it please the court. The State of Kansas appellee appears by Stephen Obermeyer, Assistant Solicitor General. It was my intent this morning to address the first 3 underlying felony issues as far as sufficiency, and the court will direct me if it has other questions, I'm sure. But as you could tell from the facts, this was a gang-related violent act that stemmed from something that had occurred the day before between the victim's brother and the defendant in this case. And the defendant is in the neighborhood of the victim the next day, driving around, and there's mean mugging going on, and an expert on gangs was called to explain how gangs interact and behave and how they're insulted and offended, and kind of explaining how this occurred. So the jury could have either believed that the defendant was going there to box, or that he, as he told his aunt after this happened, that he double backed after having been over there to kind of surprise the Brian and Blake in a different vehicle, even after having obtained a burner at an apartment complex by Martinez and driving by. So as it relates to the start with the second issue, since Justice Beyer asked a question as far as whether there was a child there. During the first encounter that morning at Echo Ridge, the child had been outside, the 7-year-old, and he was out by the mailbox with Uncle Brian, I believe. And the defendant's vehicle drove around twice. Unlike the Herndon case, where there was no evidence at all that there was a child in the truck that got struck, here there had been a child outside playing. The child's not outside when the van goes by 20 to 30 minutes later, so you could infer that the child was in the house, and in fact he was inside playing with his Legos at the time that 2 bullets entered the house, and one of them struck a TV screen, I think in the living room even.
Why, there's no evidence that they would have known that that child would be in the house, is there?
I'm
There's
sorry?
no direct evidence that they would have known the child was in that house? Is there any evidence that anyone knew that that a child resided there or anything like that?
I think the parties knew each other. I know that the defendant knew Brian and Blake. I think they knew the sister whose child was in the house, but he had been out with his uncle earlier. Whether there's direct evidence as to that, no. I think it would be a matter of inferring that there was a child inside.
I can't remember how much time elapsed between the child at the mailbox and the shots being fired.
I think I think it was 20 to 30 minutes was the time period on that one. The time it took them to get the burner and return to Echo Ridge in a different vehicle. That Patillo, whose car it wasn't, and he talks the owner of the car into driving. Patillo's driving it, and the owner's in the third seat in back of this van. As to the first issue, the aggravated assault, the state's arguing that it is distinct from the homicide so as not to be an ingredient of the homicide. And here you have 2 shots that hit the storm door of the duplex, and Brian, the victim, is sitting on the porch there. He's aware of the shots because he gets up and runs around the side of the duplex. Now, could the state have charged 14 counts of aggravated assault because that's how many bullet shells they found, 45 feet apart? No. You can charge one aggravated assault based on that, and the crime was committed for sure after Brian gets up and starts running around the house. So it is distinct from a homicide so as not to be an ingredient of the homicide.
Don't we usually look to see if there was any intervening causal impact of anything in terms of whether there was an interruption in the plan or the intent or anything? Is there anything here that would be an intervening event?
No, I don't think there would be an intervening event.
And the time is almost instantaneous.
It was, yes. However long it took to fire 14 shots in 10 seconds or more, something like that.
And the distance is 45 feet, approximately.
Right, the shooter moved that much. The victim moved a lot more than that as far as trying to get around to the back of the house, and I think he was found at the back of the duplex at the end. So I argued it's a little bit different from the aggravated assault of the truck driving into the crowd, just separated by the time and distance, both as to the victim and as to the shooter as well, and that there were several shots that occurred there. So that was the argument on issue 2, or on issue 1 rather. With regard to the third underlying felony, the discharge at a vehicle, or I'm sorry, at a residence. State versus Farmer is one of the main cases cited on that. And I kind of read the brief of appellant as, well, we should reverse the Farmer case, and there wasn't briefing as to why we should change the precedent in that area of the law. But in Farmer, there was zero evidence, according to the dissent, that Farmer shot at the vehicle in which the victim was. The victim was hit 6 times and died. In this case, it's unclear as to what Martinez was shooting at. There were 14 shots fired. There were 2 that went through the storm door. There was a bullet that hit a lamp in front of the duplex. Brian had 2 gunshots. One appeared to be a ricochet to the buttocks, and then there was a fatal shot to his right flank that hit his aorta, and he died of exsanguination in the back of the house. So unclear what Martinez was shooting at, and the jury, I think a rational fact finder, could fairly conclude that the criminal discharge of a firearm at a dwelling was committed in this case, in which harm was caused to a person, and brief that it does not have to be an occupant, that if somebody's injured from the discharge, that constitutes the crime.
You've done a lot of appeals in your time, and it relates to the criminal discharge count. One of the arguments made by defendant in the very last issue is whether or not criminal discharge of a firearm from a public road occurs every time in these cases. Is it legally a lesser included? I'm unaware that argument's been made. Apparently there's one case on it. What's your position on that?
My position is that unlike your typical lesser included offenses, burglary, a lesser aggravated burglary, we have the same elements.
It seems to fit legally that it would be a lesser included. Is it?
It's in the same statute currently. It used to be in a separate statute, the discharge from a public road. And so I think it's a little bit different in that regard.
They're not only, they're in addition to being in the same statute, they're both definitions. I mean, doesn't it start as a very broad statement that is colon, and then it lists several alternatives, and this is one of those alternatives defining the term of discharge of a weapon.
Right. It says discharge of a firearm upon or from any public road, except as otherwise authorized by law. And I think I argued that there was it was in a different statute back when it was enacted in 1969, and that it doesn't discharge of a firearm upon any public road. I mean, I think that it would be. There wasn't evidence. I think
my question is, there's a lot of kind of drive-by shooting kind of scenarios that occur from a public roadway. Would that necessarily be one of the lessers that a jury could consider or be instructed on? And here, the shooting, I think, took place from a public roadway.
Right. Although I guess there wasn't evidence that it was a public road, but it did come from that. So I guess if the court thinks that yes, that would be a lesser that should have been given, there was still sufficient evidence to support the underlying felony on the felony murder, and then it'd be a remand for trial.
My question is, legally, it would be, just looking at it, it seems to me that it could be, maybe not factually, but it could be there too. But legally, it would be a lesser included.
That might be I don't think there's any cases, I didn't find anything on that particular
Yeah.
issue.
We've never really reached it, right?
Right. As far as the jury instruction issues, they were proposed also by the defendant. I think this case is different from the case where the felony, State versus Berry, where the felony was possession of cocaine, that it would not be confusing if there's a causation relationship here between the shooting in a dwelling and homicide, as opposed to in Berry where whether there's a causal connection between the possession of cocaine with intent to sell and the homicide when the defendant was fleeing from the scene. So I think it's different in that respect, and the jury would not be confused as far as during the course of language. That was all I had as far as issues I wanted to cover, unless the court had any questions on anything else.
Any questions? Thank you, counsel.
All right, thank you.
Ms. Davis?
So, the only testimony about the child was that Brian was at the mailbox, the child was across the street. The mother said, I noticed the car coming through because I was worried, because the child's on one side of the street and Brian's at the mailbox. So the mom notices the car because of the danger to her child. That's it. There's no testimony that Mr. Patillo even saw the child, even connected the child to these people. Right? The mother said she doesn't know Mr. Patillo. Mr. Patillo doesn't know her or her child, right? They asked Blake something like, has Mr. Patillo ever been to your house or the neighborhood? He said no. The connection of that neighborhood was Marquise Fulton. They're in that neighborhood because his mother lived there. That's it. There's no evidence. He even knew that child was even connected with the dwelling, let alone somehow we can infer he knew the child would be inside the dwelling. On the discharge of firearm at the dwelling, there was absolutely no evidence to support this claim made by the state that this was a shooting of a dwelling. Every witness, you got 3 people sitting in that van, which is going very slowly or almost stopped when Martinez sticks the gun out of the car and starts shooting.
But wasn't there evidence that that Brian was kind of an accidental victim, that his brother was the person they were really upset with and the reason they went back? And I was a little confused because I saw one description that, I'm sorry, I'm blanking on Brian's brother's name, Blake, that he dove into the house as they came by, in which case could be that they saw him and were shooting at him, or if they didn't see him, that they were really just kind of that again, thinking that an inference that he was the person in the house.
Okay, there was no evidence that he dove back into the house.
There wasn't.
No. There's a detective, Blake showed up and he said, I was inside the house. I heard the shots. And
They shot 14 times.
I dove on the floor.
Okay.
Okay, and the detective said that Blake had told him when Blake was interrogated that Blake and Brian had both been in front of the house and they both ran to the back of the house. I think the detective misunderstood what Blake was trying to tell him. This was right after the incident because Blake said, no, I was inside the house. Every witness in that car, nobody saw Blake. So all of the witnesses said, the gun comes out of the car, he's shooting directly at Brian Miller. And he continues to shoot directly at Brian Miller. And that's exactly what the prosecutor argued to the jury. He said, there's someone that you want to kill, you drive up and you shoot at them. This was an intentional shooting of a person outside of a house. It wasn't a discharge of a firearm at a dwelling.
And so the shots hitting the house don't count. There's nothing wrong with that. I mean, he shot 14 times, right? And he hit
at
the
a
house.
Person.
And hit the house.
Right, at the person, right. But the
So
the
under your
statute.
theory
I'm
is,
sorry.
under your theory is, because he wanted to kill this person, the shots that hit the house don't matter.
They would for Mr. Martinez. They would for Mr. Martinez. But not for Mr. Patillo. Because Mr. Patillo had to specifically intend the crime, for the crime to happen. He had to specifically intend He was aiding Martinez in shooting at the house, and none of the evidence supported that. With Martinez as a principal, all you have to find is a reckless discharge at a house. But with Mr. Patillo, you've got to find that he intentionally aided that crime. He intentionally aided Martinez to shoot at the house. And there's no evidence to support that. The state never argued that. The state's whole argument was they drove up and he shot at a person, he continued to shoot at a person. So, and then in terms of an intervening event, I think the intervening event would be here on the involuntary manslaughter, where they said all these 4 people were, or if you believe Mr. Portillo's defense, which they did, that they were driving to the residence to commit a battery. And the intervening event would be Mr. Portillo saying that Martinez taking the gun out of the car and shooting at somebody was an intervening event. That the victim was not killed in the commission of a battery. That there was an intervening event here, which was Martinez. Every other witness said, we didn't know he was going to fire that gun. That was a complete surprise to the 3 of us. That would be the intervening event that would make Mr. Portillo not liable for a killing in the commission of attempted battery. That's where the analysis would apply. Our argument is much more simple in terms of these just was not a killing in the commission of a felony. This was an intentional killing. Those are 2 different things. So that concludes my comments.
Okay, any other questions? Okay, thank you, counsel. We appreciate arguments of both counsel, and we will now take this case under advisement.